Is it a contract of sale? Is it a deed of agreement? Is it a deed of assignment? Is it a land sale document? Today, we're talking about deed of assignment. Welcome to Real Estate with Bimpe. My name is Adebimpe Arinola, and my topic for today is what is deed of assignment in real estate? What is deed of assignment in real estate? Last video, I was telling you that I will be doing a series of videos where I will be talking about essential documents in real estate transactions. Please remember that the document is not the title to the real estate. The document is not the title to the property. The document only evidences the title to the property. So whatever kind of title a person has, the document only evidences it. That is why there are different kinds of title documents in real estate. So we say, what kind of title documents do they have? What is the title? The title is the kind of rights, the bundle of rights a person has over a real estate, over property, whether it's right to live in. You know, a tenant who has rights. A tenant has rights, possessionary rights to live in. He doesn't own. That's a kind of right. A person who the property has been used to mortgage with. Maybe I went to borrow money from somebody and I used my real estate as security, as collateral. That person also has some rights. Do you understand? So whatever kind of rights anybody has over real estate is what is called title. Meanwhile, two people can have title on real estate at the same time because the landlord, he owns the house, if you remember, and the tenant, he lives in the house because he has paid. He also has some rights. So both of them have a bundle of rights, but they are different rights and they stand pari passu on the property. So title represents bundle of rights that are owned on real estate. Documents of title mean documents reflecting the rights parties own on an estate. Now, what is a deed of assignment? A deed of assignment primarily reflects that real estate has been assigned, right? Real estate is owned by somebody. Then whatever rights that owner has in the real estate, he assigns it. Do you get it? To somebody else. That is what is called a deed of assignment. Now, that deed of assignment now contains the bundle of rights that the previous owner had, right? That is now given to the new owner. So I am assigning my rights in this property to Mr. B. Therefore, I will sign a deed of assignment for Mr. B. Do you understand? Now, a deed of assignment is most relevant. That title, deed of assignment, is most appropriate for when that property already has a C of O, for when that real estate already has a C of O, a certificate of occupancy. When a property has a certificate of occupancy that reflects 99-year assignment, you will see that in the previous video. Now, the owner of that 99 years now wants to assign what is left of his 99 years. Maybe he has had it for 3 years. He now wants to assign what is left of the 99 years to somebody. He now issues a deed of assignment. That is what a deed of assignment is. Do you understand? You know, omonile and people who own property prior to a certificate of occupancy, their ownership is freehold. Their ownership is not limited to any number of years. Their ownership is not controlled by any number of years. They own it in perpetuity. There is no challenge to their ownership on the land. There is no authority saying they own it for so long and thereafter they don't own it again. So there's nothing to assign, really, technically, in that situation. There's nothing for them to assign. They own it. But when you have gone to register a C of O with the government, that certificate of occupancy will now say the government recognizes your interest in this land for 99 years. You have now used that property for 5 years. You now want to sell. What you are doing is you are assigning the balance of your 99 years on that property to whoever you are selling to. That is why it is called a deed of assignment. So we say that you assign your unexpired residue. Residue is what is remaining. So you have had it for 5 years. What is remaining is 94 years. So you are assigning that remaining, unexpired residue to somebody for the next 94 years. That is what a deed of assignment is. A deed of assignment is different from a contract of sale in that a contract of sale is what is used to transfer ownership of land without a certificate of occupancy, where there's no government registered title on a real estate. What is used to transfer that real estate is what we call contract of sale, land sale agreement, all those things. But a deed of assignment is accurate for property that has a government title on it. And when you have a C of O once and you transfer ownership, the new owner cannot have another C of O. Certificate of occupancy is issued once on property. Thereafter, what everybody else gets when they take ownership, you understand, there are different kinds of rights, but when they take full ownership of that real estate, whatever anybody else can get will be a deed of assignment, where the unexpired residue, where the balance of the 99 years is transferred to whoever this new owner is. Did you get that? Contract of sale is used for property that does not have government title. Contract of sale, land sale agreements, they are used for property that does not have government title. Land that has government title, deed of assignment, where you are assigning the unexpired residue of ownership interest on land, right? Those are the two major differences between contract of sale and deed of assignment. So they may contain a lot of terms that are similar, but they are not exactly the same documents. Because if I'm going to investigate both of them, the places I will go to are different. The people I will talk to are different. The questions I will be asking are different. So don't say they are the same thing, because they are not, please. Now, what does a deed of assignment contain? Deed of assignment contains the names of the parties, accurate names. Accurate name. You see that name alone, we can throw the thing inside dustbin later. Let's make the names accurate names. Accurate names of the parties, the amount of money involved. We call it consideration, the amount that the property is being sold. Please note that consideration need not be sufficient. You cannot tomorrow come and say you didn't sell that sale was fraudulent. That means you, the seller, or your family, cannot come tomorrow and say that sale is invalid because the land is in Lekki and our father sold it for 15 naira. Meanwhile, at that time, land in Lekki was 75 naira. It doesn't matter how. If he sold it validly and all other factors are accurate, then he has sold that house, whether it's 15 naira, whether it's 5 naira. That money need not to be of any certain value. No, as long as there's money there, which is called consideration, as long as there's consideration there, that document is valid, that sale is valid. So the document has to contain the terms of the sale. There are certain terms, there are certain conditions upon which the sale stands. Let me not bore you with those details, but they must be contained in the deed of assignment. There must be an undertaking to indemnify. That's the only one I'll mention to you. Undertaking to indemnify, no matter how it's couched, states that if I have problem with my title in the future, the person who sold to me will reimburse me. It is usually not enforced, especially in Nigeria today, but we have to keep it there because it gives us some leverage to come back to that seller to confront them on the challenges we have on our title. So there's an undertaking to indemnify. There's a signature portion where parties, individual parties, will sign. As many as the parties are that are transferring the land, they will sign. And as many as the parties are that are buying the land, they will sign. And most of them contain a witness section where a witness will sign. Please note that that witness is not a part of that transaction. That witness only came to sign to say that I can confirm that so and so signed this document. That witness cannot testify to the details of that transaction. Please note, A witness cannot testify to the details of a transaction. A witness can only testify that so and so signed these documents, because the witness is supposed to be present when the party or the parties are signing. That is the job of a witness. So please don't give the job of witness to a person who is crucial to a land transfer transaction. Please make the person a party. Let the person sign as a party to the transaction. There are situations in which you might not have that, but in most cases you usually have a witness. Please note that when property is being transferred either by an illiterate or to an illiterate, there are certain things the deed of assignment or the contract of sale must contain. When the property is being transferred or is being bought by a company, there are certain things it must contain. There are so many considerations that will be used to determine how that deed of assignment or contract of sale, as the case may be, will be drafted. A real estate deed of assignment also contains a clause that we call the recital. The recital is the place where I will explain how you, the seller, came about the land. Because you didn't wake up one Sunday morning and then an angel told you this land is your own, go and take possession of it. You came about the land somehow. That way that you came about the land, I am going to explain it in that deed of assignment. That is why when lawyers handle real estate transactions for clients, most of the times, at least I would and my colleagues would, we would ask questions from the owner, from the person selling. We will ask the person, how did you come about this land? If you say you bought it from a family, which family? If you say you have documents of sale, I want to see the documents of sale. It is the right of the buyer to know these things, because tomorrow if somebody comes to ask him question, he cannot say he doesn't know. Police will throw him behind bars. He has to know. So you as the seller, you have to explain to him. Another question I want to answer is, how much is a deed of assignment prepared? That figure is not cast in stone. Now, let me quickly mention that there is a scale of fees to use to charge for our professional services that we were issued in law school. At least in the days in which I went to law school, we were taught the scale of fees that we should use to charge for our professional services. Please be informed that if we use that scale of fees, the money is over the roof. The figure is way over the roof. So what is generally used in recent years, so that clients don't think they are being scammed, so that they understand how the lawyer comes about his fees, is a percentage of something fixed. Do you understand? The value of the property is fixed, it's not varying. So the lawyer charges a percentage of that. Ideally, standard, we charge 10%. However, there are other factors that are brought into consideration that the charges can be reduced. There are different allowances that different lawyers make in charging to draft a contract of sale or a deed of assignment. Therefore, I cannot go into that specifically now. However, I need you to know that the discussion revolves around 10%. You can go up and you can come down. And there are different considerations for why it will go up or it will come down. Now, as to who prepares a deed of assignment or a contract of sale. Usually, in transactions that are going to be documented, the party that will lose out if that transaction is not documented is the party that will prepare the documents. The party who is likely to lose his money, who is likely to lose his investment if the real estate transaction or any transaction is not documented, is the party that will prepare the transfer document. He is the party that will want to safeguard his interest by preparing the transactional documents. In this same case, the purchaser, the person who purchases, who pays the purchase money, you know the land doesn't move. And as of today, the person who is known to own the land is the person selling. So if the person buying now wants to be known to own the land and doesn't want to have challenges on his title, he is the one that will get somebody to prepare it. So the standard practice is that the buyer is the person who gets a lawyer that will prepare the real estate transfer of title documents for him. It is the buyer who is at risk of losing his money. He is the one to further that cause. That's why if you buy property and you don't take documents to the people sold to you, they are not likely going to challenge you. Most people will not, because they don't lose anything. You are the one that will lose if you don't have proof of ownership or proof of whatever it is that you have on the land. I hope you understood the things that I discussed in this video. If you didn't, watch it again. And if you have any questions, please drop them in the comment section. I will answer them. If you also have any topics you want me to touch, drop them in the comment section. I will address them. If you got any value from this video, please do well to like it and hit the subscribe button so that you know when next a video goes live. Thank you for watching.